are our implementation issues surrounding legal representations. We are not state courts. We are not state employees. We are county courts. And that means that we have a small amount of money that is a state grant. It's based on the number of Superior Court judges. It goes for salaries. There have not been increases in funding during these very difficult budget years. And as I've explained to you, our work is harder now than it has ever been. One of the things that I didn't understand that we are facing is that when we changed mental health and deinstitutionalized dealing with acutely mentally ill parents, they are now in our communities, and when they give birth to their children, when they are not psychotic in the hospital, they are not being removed and raised by other family members, they're being raised by those parents. And typically we're not seeing them till they get to school, and then we have some very serious issues with the children because there has not been the early services and the things that need to happen to assure that those children get off to the best start. So we've got some very serious issues that we're going to have to be prepared for dealing with. And then we're placed as judges of having to go to county commissioners, and I'm lucky because I'm in a judicial circuit that's in one county, but many judges have 2, 3, or like Judge Spivey, who has 9 counties, that he has to go and ask for money from 9 counties. You have to ask for your salary, you have to ask for your staff, you have to ask for indigent defense needs. And so what happens across the state is that the availability of these things depends on how generous or how stingy local government is with the juvenile courts. So this is a very important issue for you to understand the functioning of the courts. There are many judges who don't have offices, who don't have staff, who have a computer and a car and travel from place to place. Another issue is availability of attorneys in all jurisdictions. We don't exactly pay a lot of money for representation of children. It's a very low rate. So the issue is, how do you get enough people? And one of the things I've asked you to think about is think about recruitment of retired attorneys, retired judges, new graduates, maybe a student loan credit to serve. I'm sure that there are many people who would love to work off some of their student debt. And then we need to think about training them as child welfare specialists. We are very fortunate having some of our specialists here. So we may want to consider things like incentives to achieve certification. And then the payment of attorneys for representation. We may want to consider things of state grants for paying child welfare specialists to assist with representation. We also require, not only does the child have an attorney, the child has a guardian ad litem. The attorney is in the attorney-client mode, saying that they will be self-directed by the child when the child is able to express their desires, but the guardian ad litem's role is different. The guardian ad litem's role is to advocate for the best interests of that child, not what the child wants, but what the child needs. And as you know, once children reach 12, what they want and what they need are often very different. The child's attorney can serve in a dual role when there's not a conflict, and the mandatory appointment of a CASA where it is possible. And we cleaned up the statutory language, and I appreciate the help from the governor's staff in cleaning that up. We had inadvertently put in a provision that CASA could be appointed in delinquent cases. This was a violation of the national charter, a violation of the state charter, but we have remedied that. Mandatory training is required, and that is approved through the Office of the Child Advocate. Guardian ad litem duties, I'm not going to go into those, but please read my presentation. The code is wonderful in setting out very clearly what best interests are, what the duties of the guardian ad litem are, and minimal standards. We actually say specifically what it is that people have to do. In-person contact. If I put something in bold, it's because I think it's important. And this has to be prior to the hearings. We were running into problems with attorneys, we were running into problems with guardian ad litems of only seeing their clients in court. That's not good legal representation. They have to consult with the child's attorney, and this is important, communicate with healthcare, mental health care, and other professionals. The team that supports the child, the guardian ad litem, is to communicate with them and protect cultural needs. contact the child prior to a proposed change in placement, contact them after the placement, and get them into court as is appropriate to do so if there are not hearings scheduled. But I just wanted you to see how many things we've said are must-dos. I want to brag for a moment. The National CASA Volunteer of the Year, Millie Bush from Canton, Georgia. We have just come from a national conference. Dwayne Hathaway, who is the head of our CASA program in our state, is here. The CASA program does magnificent work. We have to have the swearing in, the training. They are in dependency cases. Their role is best interests. Court retains authority over the CASA program. But here are the issues. CASA continues to grow, but we are not yet, even though when I served on the Georgia board 10 years ago, our goal was to have a CASA for every single child in foster care in Georgia. That goal has not yet been attained. We're much closer than 10 years ago when I was on the board. Federal funding for CASA has been significantly reduced. It's gone from $12 million to $7 million. State funding has remained steady. There has been some increase this year. The quality of the advocacy and the training continues to improve, but fundraising is extremely challenging. And I hope that you will take the time to talk to Dwayne about the CASA program, and I hope you will take the time to visit the CASA program in your community, because it is extremely important to have the community involved in our work. Now, why would I throw in this thing for spiritual treatment? Dr. Greenbaum, I'm so glad that you are here. Those of you that don't know Dr. Jordan Greenbaum will get to know her over the course of this work, because she is an outstanding representative of Children's Healthcare of Atlanta. And as a juvenile court judge, you become very intimately involved with Children's Healthcare of Atlanta when you are dealing with challenging issues. I had the most stressful 90 days last August with a child who was facing very, very serious medical issues. Her family's religious beliefs prohibited her from having blood products. She was going to die. She was 15 years of age, and she wanted to get well. And Children's Healthcare of Atlanta notifies the department, that notifies me, we have a medical crisis. And I walked for 3 months with my phone in my hand everywhere I went, because the parents would not consent to treatment. And I had to exercise authority, override the decision, and authorize every single transfusion that this child had for 90 days. And if you have any idea what responsibility it is to be respectful of someone's religion, to know that you are going against parental desires, but you are listening to a 15-year-old who wants to live and who is suffering mightily, and listening to medical professionals begging you for authority to treat that child, you don't want someone in that job that doesn't know what they're doing, because those are the most complex legal issues that you will ever face in any court. So, that gets me to why I left that slide in there. Training for judges was cut from the ICJE budget. We have much less training, and the quality of our training is not nearly what it used to be. And that's the Institute of Continuing Judicial Education, because I saw people going, ICJE, what's that? Many judges now attend only one training a year instead of 2, which was customary before the cuts. And you have to understand that the way our appointment process works, we are not elected. We are appointed with the exception of Floyd County, which is elected. But every other county, we are appointed by the Superior Court judges. And the person who comes into that office may have never walked into a juvenile court before. And all that's required is 12 hours of training in your first year. Now, we do have money that is in the AOC budget that comes from federal money, where we can send judges to Child Abuse and Neglect Institute training. And this is a very, very intensive 40-hour training for judges on nothing but abuse and neglect. But Going is voluntary, but we still try to encourage our new judges to get that training. The Council of Juvenile Court Judges realized that we have a lot of people retiring, a lot of new judges coming in, and we are now offering at least some basic training for new judges. Thank you for the statute on continuances, because basically it says we have a duty to hear these cases expeditiously, do not grant a continuance unless there's good cause, and it defines a whole bunch of things that are not good cause. Convenience of the court is not good cause, convenience of the attorneys is not good cause, discovery is not good cause. So these conflict cases with criminal cases and family law is not good cause. So these are things that have helped us tremendously in getting people to come to court and try their cases. Also, the legislature has given judges much more oversight. We have much more say in what the department does and in accepting the work from the department or rejecting the work from the department and asking them to resubmit it. It does require us to make a lot of findings of fact, however, to be able to do that. Here is the implementation issue. We absolutely have to train judges, attorneys, guardian ad litems, CASA, about what are the standards. How do you know you're getting quality work? How do you know, for example, that a substance abuse assessment is a valid one? What are the oversight powers of the court? How can we use a no reasonable efforts finding when it's necessary? Because one of the tricks of the trade as a judge is you say, you know what? This is not reasonable efforts. But instead of making a no reasonable efforts finding today, I'm going to give you 30 days to figure out what it is you can do to address this problem. I'll bring you to court in 30 days and you can tell me how you're going to address this problem so that I can make a finding that the department has made reasonable efforts. Now, visitation changed dramatically. We have a presumption of unsupervised visits, and there are a lot of requirements set out in the visitation statute. We have to decide frequency, duration. We have to review our visitation orders when there's a lack of substantial progress. But here's the implementation issue. How am I going to order visitation when I'm in Douglas County on the west side of Atlanta and these 3 children are placed in Savannah? We are struggling. We have to have more foster homes in proximity to parents. There is not money to assist with transportation for visits. And visits are what gets people to do their case plan and get their children back. So we have a very serious problem. If I make a no reasonable efforts finding, I've made budget matters worse because the federal money is not going to come in and it's going to have to come out of the state money. We do not have the money for the in-home services to address the relationship between the parent and the child. We're doing some great trauma forums around the state. We did one at the Carter Center. We just did one at Savannah. The last Friday in June, we will do one in Dahlonega. The last one is in the fall in Tifton. And one of the things that we know is that the very intensive services between parent and child strengthens that relationship and reduces the likelihood of abuse and neglect by 40%. So we've got to do more child-parent psychotherapy, we've got to do more parent-child interactional therapy, and we've got to do a lot more cognitive-based, trauma-focused behavioral therapy. So again, I raise the issue, do we want to look at 4E waivers to have the money to fund things like that?